Well, good afternoon, everybody, and welcome to our Miller, Tracy, Braun, Miller Winter Workshop, where we've got some really good information to share. Good in the context of you need to know it, and then it's going to be important for you, not so much in the it's everything you're going to want to hear. I know that's true for part of what I'm going to share with you today, but we do have some good stuff, and we're going to leave plenty of time at the end to do some Q&A as well. But as we go along, don't be shy about asking questions in the Q&A box. We've got the Q&A box up and open. So as you have questions, please type those in so that we can answer those questions. To get through our content, we may save some of those for the end during our Q&A piece, but please, as we're going, please do so. I'm joined today by some of my favorite people on the planet and my colleagues, David Braun, Ellen Looking, Christine Christensen, and Anastasia Brunner, who we're going to cover quite a variety here in a pretty short amount of time. And so our plan today is to make sure that's on your radar, some things that are important for us, some of these things you might have seen in our newsletter that went out this week. So make sure you're taking a look at that to maybe read that and dig into that with a little more detail. But we're going to kind of move through several topics this afternoon and then open it up for Q&A as we go. So again, don't be shy about the asking questions. And I think, David, you're going to kick us off. So let me turn things over to you, and we'll go from there.
Sounds good. Good afternoon, everyone. It's really nice to see everyone in scare quotes, see all the names. Look forward to your questions when we get near the end. As we're going through today, one of the things that I'm going to start with is just some labored updates for 23. Some of these things I think are going to be a little bit of review for some of you. Some of them will be new. Some of them are reminders. There has not been a huge change to non-renewal law, but what there has been is a huge amount of cash flowing in and not enough people to pay. And that means that what we're stuck with at the moment is cash that's about to evaporate, one. Two, we're about to see, I think, an influx in folks who might not have been hired in the past, who are sort of sitting there and are folks that maybe you'd like to get rid of. And then three, sort of that toxic mix of the money's about to evaporate. We've got folks who aren't there. And then a lot of people in the programs that are going to come out and suddenly be available because, of course, there's been a ton of money at the educational institutions for scholarships and other such things to try to drive enrollment. And so with that starting, I think there may be some new candidates out there that some of you may be interested in hiring. And so as we move into that next slide, I want to make sure that we're starting to think a little bit about what the differences in the statutes are, because I think some of us haven't done this in a while. And it's really important that we remind ourselves, because I've already gotten a lot of questions this year, frankly, from some really experienced folks who know the rules really well. But it's been long enough since we've had to do this that we have sort of forgotten some of the distinctions in the statutes. And so I want to make sure that we're remembering those now as we're starting to think about that process for the spring. So there are two different places where the word non-renewal comes up, and very confusingly, they're right next to each other in the statute. One is 24-11, the other is 24-12. They are different. They're critically different. And that's been true since about 2009, when the statute started its big change that started with the Performance Evaluation Reform Act. Because of the distinctions in those two statutes, one of them is a cause-based dismissal. The other is what we would call a RIF, or a reduction in force, or a layoff. A layoff is blind as to person. I don't care who we get, I just need one less person. A layoff is also blind as to, can also be as to program. It's blind as to person, but it's about programs. I don't care who we get, but it's got to be a music teacher. Those are both straight RIFs. Yes, we happen to have one music teacher. That is what it is, but it's the music program I'm trying to get rid of. Yes, I have 30 teachers. I need 29. Don't care who it is. Happens to be one of my most valuable teachers. It's at the bottom. Tough. That's who I'm getting rid of. But you need to be careful to distinguish it. What I hear all the time is, no, it's a first-year non-tenured teacher, I don't have to give them cause. Or no, it's a fourth-year non-tenured teacher, I don't have to give them cause. Well, let's start with the fact that with a fourth-year non-tenured teacher, yes, you do. With a fourth-year non-tenured teacher, you're required to provide cause in the resolution. Now, that is bare cause. It is not just cause. It's not substantive cause necessary for a tenured teacher dismissal. However, it is cause that you have to be able to establish. Now, cause is not just, I don't want you here anymore. It actually requires some legitimate non-discriminatory cause. And additionally, and maybe more importantly, when I'm doing a non-renewal, I need to be able to establish whether or not this person is going to have recall rights. And remember that at the same time that the statute extended the recall rights to non-tenured folks, it also made another change, which is that that statutory window may be as much as 2 years if you're riffing enough folks, and that number came way down. It used to be a dramatic amount more a dramatic amount more if you dismissed a dramatic amount more staff than you have in the past through a reduction in force. Now it's just if you have 5 or more people, or a dramatic amount more, whichever is less, and that's important. In other words, if you're going to move to reduce folks out of their jobs, be aware that you may be conferring on them the right to their job back if that position comes open later. More importantly, I'm just going to acknowledge who I am. I'm sort of a straight player. And my view is if I've got the goods to dismiss you, I'd rather just tell you straight up, you're not meeting my expectations. I'd rather just, I want to coach you as hard as I can coach you to try to keep you here because I want you to succeed as a teacher in my district. But at the end of the day, if you're not going to succeed as a teacher in my district, better that we should be direct with somebody, because here's the calamity. The calamity is that you tell somebody, look, I really like you. I think you're great. Maybe, I don't know that we're going to have a position for you next year. So maybe we should part ways. You try to be nice about it because you think you're sparing the person's feelings and they think, oh, okay, so we're just doing a riff. And then they find out that somebody else got the job and that person happens to look different to them than them. And they think to themselves, now, wait a minute. You told me I was good at the job. I know I could get the job back. Maybe the only reason you got rid of me is because I'm, pick your protected class, male, female, black, white, Asian, Latino, religion, military status, disability. There's so many different protected classes. They've got a mechanism to get there. And the problem is that we now have to disprove that's the cause. If I don't have evidence to disprove that, there's no mechanism for me to get there. And so as we move to that next slide, I think it's important to remember that we have to distinguish it. Brandon, next slide. Thank you. It's important that we distinguish cause in the resolution from the cause that I need to dismiss. In other words, I don't necessarily have to say it in the resolution, but I do need to have the capacity, the ability to defend that it is this cause and not whatever crazy thing is in their head. That's what I need in your resolution. That's what I need in your paperwork. So in the resolution, I'm going to distinguish which statute I'm under, 24-11, 24-12. If you are using an old form resolution that you think looked great 20 years ago, be alert. We change these things every year. We don't have a form. I know that's a big myth out there, is that we've got some form and we just fill in blanks. It doesn't work like that. We redraft paragraphs every single year. And sometimes it's as small as one word, but that one word could be a very big difference. So if you haven't updated what you're doing in a while, I'd strongly suggest you just taking a look and just working with somebody and making sure. But 2, make sure you've got the documentation already in place. If you're a new superintendent of school and you got 3 principals, check with those principals when they say, hey, I want to non-renew this guy, and this gal. Make sure that you're actually looking at those evaluations and asking yourself, do I understand what happened? And if the answer is no, if it's not clear that person understood they were going to be dismissed, back up a little bit and ask yourself if there's something more you've got in the file that would prove this isn't discriminatory. Remember, 24-12 is silent as to person. And so we're just looking at program or number of people. So that's my first big reminder for the year on labor. The second one is Scanlon versus Ignite. So this is an odd case that I think, this is a situation where the court has sort of reaffirmed something that's already in the statute that frankly might be something different than you've been told in the past. But more importantly, as I've read around the internet, I've read a whole bunch of different articles on law blogs and other places, and even on one of the union's websites, I saw this case cited with an explanation of certain things. And I thought to myself, as I was reading that, I thought, now wait a minute. I think this is being mismarketed. I think people are reading this case to say something it doesn't say. And I want to be careful that we're not overreading this case, because this is a peculiar case. And I don't know that we get the same result every time. So what this case did, we had a former employee who argued a lack of compliance with the Personnel Records Review Act. They'd said, look, I have this personnel file that you guys all maintain. That file needs to be sent to my lawyer so that I can have that file to sue the employer. Of course, you all know what's going on here. This guy lost his job. He's upset about it. He hires a lawyer. He moves away. He hires a lawyer, says, lawyer, handle it. Lawyer's used to making a demand and getting what he wants. Hey, send me a copy of the file, because that's usually how it works. But this is a big company, and the company says, no, I'm not sending it to you. I'll make it available in the file cabinet here. It's a big file. You can come get here. You can come get it if you want it. I don't know if Scanlon had a case, but it may be that Scanlon just didn't have a case. And so instead, they argued a violation of the Personnel Records Review Act. Now, that would be an extension of the Personnel Records Review Act to require a copying of that file and delivery to the attorney. And so I read a couple of blogs that were like, hey, the Personnel Records Review Act has been very narrowly construed, and that means you don't have to send file to the employee when they ask. And I read them on a couple of places that represent a lot of public employers, and I thought to myself, that's kind of scary that we're reading that case that broadly, because there's another act that's also at issue. As we move to that second slide here, an employer oftentimes has a union that is involved. The union has a right under the Labor Act. It's not the Personnel Records Review Act, which frankly, when their requests come in, they often cite the Personnel Records Review Act, but that's not their primary right to information. Their primary right to information comes under the Labor Act. And that means if we fail to provide them the information they need to prosecute their case and in order to represent their members, we potentially have what's called an unfair labor practice, ULP. And that ULP could be damaging to the district, because not only can it result in the labor board having jurisdiction in the underlying claim, potentially, but it also potentially results in certain damages that the union gets, and frankly, subjects you to having to bargain out what may be something as simple as a disciplinary matter, where an arbitrator wouldn't have any jurisdiction over the substantive cause that's involved in the discipline. So in order to avoid that, I'm suggesting two things. One, remember that the union represents all staff, not just this staff member. So as opposed to an individual employee who hires their attorney, where they have one issue involved, the union is looking to make sure the rules are fair as applied to everyone. And that means if this employee is a problem employee for all the other employees, the union has a duty of fair rep to the rest of them as well. And so helping you build that file may be helpful. Sharing that file with the union, there is no privacy right as against the union. The union gets to see it. So first, I mean, yes, you could make them come in and have copies and all that. I get that every so often where the board really wants to play hardball and says, look, if you want it, come get it. I think every one of us who, as I look on my screen here, all of us work with attorneys at the unions. We've developed good relationships. And one of the things that we emphasize routinely is provide that if we've done it right, we want to provide them the information. If we've done it wrong, we want to know we've done it wrong. So instead of relying on Scanlon versus Ignite as a weapon, as a sword, I'd view it as a shield. That's one act that's been taken off the table to weaponize against me. But I don't want to use it unless I have to use it. So instead of reviewing this case as a big win for us, it's just one more shield that I potentially have. Don't use it as a means to pour gasoline on frankly, a fire that represents an already okay relationship. There's one more case I want to make you aware of, and it's a case that just came down yesterday. It was published. It's Barrow versus Lake County IFT-AFT. This is a case of an employee suing their own union. They're not really suing the employer. But the reason I raise this case is because it's a reminder to me as we go back to the bargaining table to check in on something that we were advising you guys to do just a couple of years ago that I think I pulled a bunch of contracts this year and was looking at contracts and saw a whole bunch of contracts didn't have them. And so it tells me that we didn't all get that message in. And it's important that we, as we go back to the table, we take this opportunity, because here's another place where I can point to a change that gives me cause to come back to the table and talk about it. And that is dues deduction. So a lot of school districts eliminated fair share, and when they did so, they also eliminated anything on dues deduction. Or if they had dues deduction, they just have a one-liner that says, okay, if you want to be a member, you'll deduct dues. Well, so what happened in Barrow versus Lake County, now, when that all came down, when Janus came down and they said it's unconstitutional to have fair share fees, that is, everybody has to pay whether they join the union or not, I'll be honest with you, I had no idea what was going to happen. I wasn't practicing law in 1971, so I had no idea what was going to happen as it was back in 71, 75, 77, before the US Supreme Court had ruled in the Detroit case. And I wasn't really sure what was going to happen. And thank heaven that we have a firm full of Tom Miller and Braun and Bill Tracy, and those guys had all practiced back in those days. And so they were like, it's just going to go back to the old way. This is not a big deal. It's just contracts. It's contracts. It's contracts 101. It's just, they're going to send us a contract. The union is going to send their members a contract. The union members are going to sign it, and that's going to be it. It's a contract and it's binding to them. And in the early days of this, I was getting contracts that were coming from the union with all kinds of crazy language in them. And I thought, well, I don't know if these contracts are going to be good. Well, the first of these contracts went up before the court. And it's a really interesting fact pattern, because this employee said this contract is invalid because I didn't understand the contract. And then she made that argument to the union, and the union said, okay, fine, we'll give you your money back. And then she sent it back to the union and said, no, I don't want the money. This is an invalid contract. I want to blow up the union. Therefore, this is unconstitutional, went to court. Those facts are important because this is a really extreme fact pattern. But it also is an example of how the school district ends up wrapped up in this whole thing, because the contract is, your privity of contract is between the union and the employer. It is not between the employer and the employee. Your privity of contract is with that union. The union has a contract with the employee. So the Supreme Court, or the court ultimately held in this case, no, that's not how it works. It's a federal court, and they held that they had reaffirmed their reasoning in Bennett versus Counsel 31. They said there's no secondary analysis of consent. We don't have to check to see what your state of mind was or figure out subjective intent to the parties. We only have to look at the contract itself. If the contract is good, it's good. That's it. The reason I want to make note of this is because this is an appellate court case. Those are expensive, and it's not your fight. I shouldn't be defending whether the union's contract is good. Make sure that you've got hold harmless and indemnity language in your collective bargaining agreement on dues deduction. If you are doing dues deduction, make sure that the union is defending that dues deduction, because that's a favor to the union. You're not required to do it as a matter of law. On the last issue, I want to talk about bargaining, because of course, what would an annual update be in the spring without at least a brief discussion of bargaining? Short-term money is running out, or it's already committed. Inflation remains high. We're still seeing in the 7s. 6% limitation remains an issue, and I've already seen some collective bargaining agreements that have exceeded it. And I heard in lots of places, well, I don't have anybody who's going to retire, so what does it matter? Okay, so I do 8%, I do 10%, nobody's going to retire. That's all well and good, so long as it remains true. If you have somebody who is, say, in their 40s and decides they've had enough of education, they get out, and that's happened a lot this year, and then they elect their pension 10 years later, their best 4 consecutive, their last 10 of teaching was in their 40s. It could also happen with death benefits, could also happen with other things. And so you need to be aware it's not a guarantee. I've had other districts that said, we're just going to take the penalty because we're flush with cash. And that's great so long as you've committed that that short-term cash to that long-term purpose, but make sure that you're doing what you need to be aware of that. But watch out for auto inflation as a function of your base, because the 2 things I'm really watching this year are, 1, a lot of people issued bonuses last year. A lot of districts issued bonuses. And as they issued bonuses, I want to know if those bonuses stop or if they keep going. And the second issue, and the one that worries me even more, is if you don't have a practice, or if you don't know what your practice is, as your base goes up automatically with CPI, which is going to happen after this year, be aware that could inflate the entirety of your schedule. And so you better handle that in your collective bargaining agreement. And I think that's all I've got. I think I'm handing it off today now to Ellen.
Yeah, I think as we transition, I would say one thing here is that if people want some much more information and a deeper dive into that first topic you covered, the RIF versus dismissal, you and I did a webinar on that about a year ago, and that's on our YouTube channel. So if you want a much deeper dive into that with a lot more detail, with David and I discussing that issue, feel free to check out our YouTube channel and that RIF and dismissal webinar from last year. But I'm going to hand things over to Ellen, who's going to talk to us about some issues with Title IX.
My favorite topic in the world. So I have noticed a handful of places where there are some issues with districts complying with Title IX. And part of that is a function of a lot of districts are encountering their first Title IX complaint after having been back at school, and they were focused on COVID issues. And now is really the first time they've had an issue. So as we are looking at these, there's a few places that it's really easy to be in compliance and to correct your compliance. First, the Title IX regulations at 34 CFR 106.8B2I require that each district prominently display, and that is in quotes, prominently display their Title IX coordinator's contact information on their website. So if the only place that your website lists the Title IX coordinator is within board policy 2265, and that board policy is only contained within your board policies link or the binder on your school board section of your website, I would recommend getting with your website manager and finding a more prominent location to post your Title IX coordinator's contact information. Again, this is such an easy compliance issue. So hop off of this webinar later, check your website and see if a change might be necessary. In my ideal world, you'd have a whole landing page for your Title IX on your website, because there are a number of items that you're required to post with regard to Title IX. First is the training materials used by the trainer for your Title IX personnel. This is generally done in the form of handout materials or a PowerPoint from the trainer. 34 CFR 106.8C requires that a recipient must adopt and publish grievance procedures that provide for the prompt and equitable resolution of student and employee complaints. Most districts at this point have adopted PRESS, which includes the Title IX policy at 2265. However, the procedures are largely contained within 2265 AP1 and 2265 AP2. And there are some really important definitions necessary to understanding the policy and grievance procedures that are contained within 2265E. So I would highly recommend posting 2265 AP1, AP2, and E on your website. Otherwise, I don't know that parties know what they're getting into as a function of a Title IX complaint. And I do think that the Title IX regulations require you to do so. So again, in my ideal world, you'd have a landing page that is somehow hyperlinked on your main page that just says Title IX, and you can get to your Title IX coordinator's information, the training policies, the policy itself, 2265, and the grievance procedure. As we're moving on, when you receive a notice of a Title IX incident or an incident that may rise to Title IX misconduct, the Title IX coordinator must promptly meet with the potential complainant to discuss supportive measures, to consider the wishes of the complainant with regard to those supportive measures, to discuss how to file a formal complaint. And I think in that conversation, as you're discussing how to file a formal complaint, it is a great idea to discuss what that process looks like and provide a hard copy of the 2265, the administrative procedures, and the exhibit that I previously mentioned. And then finally, the Title IX coordinator needs to explain supportive measures that are available with or without a formal complaint. I like to call this process intake because it is required to happen promptly. As a practical matter, it's important to have a Title IX coordinator trained and prepared to do this because you never know when a Title IX incident is going to arise. There's a little bit of time once a complaint is filed to get your decision makers into place, but there isn't time to get your Title IX coordinator into place. And frankly, the regulations require that you have one in place currently. So make sure that you have a Title IX coordinator on staff who is trained, and we do have on-demand training available, and who is prepared to move on an incident if one should arise. I often hear that the hardest part of these Title IX regulations, and I agree with it, is when you're in a K-12 setting, some of this feels like it's just kids being kids or normal child development, learning boundaries, learning what's okay and what isn't okay. And because it is so hard to differentiate and to distinguish for the purposes of liability, I think the best decision here when you have notice of anything that may be Title IX sexual harassment is to have the Title IX coordinator complete the intake steps. It prevents liability. It sounds scarier than it is, that first initial conversation. It isn't scary, and there's no harm in having that conversation, and it shows that the district has taken some action, which is good for us on the back end if you should have an issue that proceeds to litigation or to OCR. Even when you wind up with a Title IX formal complaint, it doesn't necessarily mean that that is where it belongs. It may be filed as a Title IX complaint, but there is a process for dismissal if it doesn't meet those definitions of Title IX sexual harassment, or for other reasons it should be dismissed. And this is where a complaint can leave the Title IX process. And this is where we see that normal kid stuff leave the process. So there is a mandatory dismissal, which is appropriate where the conduct did not occur in the district's education program or activity. Here, the Title IX coordinator needs to watch for conduct that occurred outside of the education program or activity, but has bled into conduct that is occurring at school. So perhaps the primary incident occurred outside of the school on social media, or outside of school at church camp, wherever that is. But now there's harassment going on about the incident during the school day. Here, when we're looking at the second one, that is pretty rare to happen in our K-12 districts. That's really targeted for study abroad in the university and college setting. But the third one is where things get really tricky for Title IX coordinators. So let's take a look at the definitions of sexual harassment under Title IX. The first and third here are pretty clear. Quid pro quo from an employee to a student. So they're asking for something in exchange for some sort of unwelcome sexual conduct, or these are clearly defined as sexual assault, dating violence, domestic violence, or stalking. We know what those are. Those are easier to recognize. The second one is where it is difficult to evaluate, especially in that K-12 atmosphere. So this is the severe, pervasive, and objectively offensive standard. The conduct alleged, as it is alleged in the complaint, must be all three. And when it is not all three severe, pervasive, and objectively offensive, that is when a dismissal is mandatory. And this is where the normal kid stuff might get dismissed. However, that does not mean that we just forget it ever happened or we drop the ball. You do have a duty to maintain those records for 7 years, and you're also going to be watching for repeated incidents of that same or similar conduct. So while one incident may not rise to it, if you are seeing a second, a third, a fourth, there may be some necessity to engage the Title IX process later on and not dismiss it. A dismissal notice is issued to both parties, noting their appeal rights amongst other required items, and an analysis of why this conduct, as it was alleged, does not meet the standard of severe, pervasive, and objectively offensive. Those appeal rights provide an opportunity to argue against dismissal and to reframe the complaint to fit within that if there is conduct that perhaps they just didn't include and expected the opportunity to talk about. So as we move on, there are also permissive dismissals. So this is where the complainant wants to withdraw the complaint, the respondent leaves the district, or there are other specific circumstances that do not allow the district to reach a determination as to the complaint. We see that the final one often in the case of truly anonymous complaints, so mailed in, no return, anonymous emails. As a reminder here, the Title IX coordinator should evaluate if the complaint must continue because it continue to be processed, because it would be clearly unreasonable in light of the circumstances not to. So if you have an allegation of employee on student conduct and the respondent leaves the district, it might still be necessary to continue that investigation. If there's an allegation of violence, you might also want to continue to investigate, or other very severe conduct that is impacting the educational environment for not only the potential complainant, but perhaps even others. So as I mentioned, a notice of dismissal has required parts, which include a notice of the appeal rights and the facts supporting the dismissal. This is where we, as your school attorneys, would be looking for evidence supporting your decision as reasonable in light of the circumstances if you were to be challenged in litigation or with OCR. There are many times that the district makes determinations on the next slide. Yep, there we go, about how to proceed in the Title IX process. So if there is a dismissal, the district may still implement supportive measures to that specific student or to the educational environment, or both. But sometimes documenting those measures that they're continuing to take in a dismissal notice or something like that, especially as it relates to other students who have not been found responsible, might be inappropriate to include in the dismissal notice because it may include other students' student records. So if we suppose that there's a student who engaged in a clothed grope of another student's bottom a single time, and there is no other reported conduct of that student engaging in same or similar conduct, the Title IX coordinator would proceed to dismissal because the conduct as it was alleged is not severe, pervasive, and objectively offensive. It doesn't meet all three of those. It might be objectively offensive, but only one time is unlikely to be pervasive unless they disclose something later, and then we're going to reframe that complaint. But the Title IX coordinator may find it necessary to inform that student's IEP team if that student has an IEP, because that information may be relevant to the student's social emotional needs. And you want to document that somewhere, but it's not appropriate to document that in the dismissal. The Title IX coordinator may ask the social worker to engage in a couple sessions of discussion of inappropriate touches, or may have the social worker present to all the third grade classes about what inappropriate touches are and keeping one's hands to themselves. So finally, the hardest part of all of this Title IX issue is that no discipline can occur until after a finding or until after dismissal from the Title IX process. And this is abnormal as to how K-12 districts usually handle student misconduct. But it is important to remember that when you hear that a student has groped another student, we don't immediately proceed to discipline. We have an evaluation of Title IX first. Thank you. And I am passing this off to Brandon, I believe.
You are. So thank you, Ellen. So much good stuff on Title IX. I mean, we could talk about that for an hour by itself and not cover everything. But again, if you guys have questions, pop them in the Q&A, and we're going to come back and do the questions at the end. So please don't be shy on the question front. So it's my turn, and I want to talk about two different issues here in my few minutes that I have with you. The first one is the Faith's Law Trailer Bill, Public Act 102-702. Then I want to talk about a recent student social media case that I think is really important to have on our radar as we continue to figure out how the lower courts are going to be implementing the Supreme Court's decision last year in Mahanoy. So let's let's talk about this trailer bill. Hopefully, I'm starting with the premise that we all are kind of up to speed on Faith's law to begin with and what we had to do this school year already. Although I say that with a little bit of trepidation because I know that I still get a little bit of learning that we're not fully compliant as I talk with everybody and as I talk to districts. So I do think that is something we want to make sure that we're compliant with. But 102702 is going to hit us in July and is going to be a big deal. I don't predict that it's going to really change or be amended this spring. I think we're going to have to be ready to deal with this. And again, I'm going to hit the high points here over the next couple minutes. This is a topic that if you want to get a little more deeper of a dive on that, we did put out some info in our newsletter this week on that and on our website. So there's a longer article there to read to kind of go through the details of what's out there from our requirements here with 102702. But there really are two different main components of this. The one I'll spend less time on is the requirement to notify parents when it's alleged that their child is a victim of sexual misconduct by a school employee or contractor. So there is a parent notification piece that we're going to talk about. The piece that I think is going to be much more, and there's some very specific requirements in that we need to talk about. The piece that I think is going to generate a lot more questions and obviously concern because I think it's going to be difficult to do. And the feasibility of it is going to be very difficult, is expanded requirements for all applicants of employment for the district or any contractor to both affirm that they have not previously engaged in any sexual misconduct against a minor. Again, sexual misconduct as specifically defined in Faith's law. And we're going to have to do some digging. So they're going to have to disclose every place they've ever worked where they may have worked directly with a minor. And then we're going to be required to contact them to get that former employer certification that they did not engage in sexual misconduct when employed by them before they can work for us. And I think those are some big deals. So let's talk about that in a little bit more detail here. It creates a new section 2294 of the school code. It applies to all permanent and temporary positions with a school or a contractor for a school who would have direct contact with students, which is defined as the possibility of care, supervision, guidance, or control of students or routine interaction with children or students. So obviously it's going to apply not only to our employees, but also to if we subcontract for transportation or cafeteria work or those types of things as well. And we're going to have to go through that process. So first, as part of the application process, beginning July 1, all applicants are going to have to affirm that they're not disqualified, and ISB is going to be required to create a template that they're going to be required to fill out. That's going to include the contact information for their current employer and all former employers that were schools, school contractors, or where they had direct contact with children or students. So if they were a lifeguard at the YMCA when they were 19 years old, they're going to have to list that. They're going to have to, as part of their application process, authorize that we can contact them and a statement as to whether or not there were allegations or findings related to that, unless the allegations were false, unfounded, or unsubstantiated, right? So that is an important piece to it. So what are we required to do as the employing school district or the contractor? We have to initiate a review of that employment history by contacting each of the employers listed and using ISB's template, request from them the dates of employment and a statement that affirms whether or not there were allegations related to, a finding of allegations related to that. And then we're also required to verify their report of previous employers with ISB's licensure database to make sure that it is accurate. So please make sure that we're doing that. So those are things that we're going to be required to do. And then people have 20 days. So if you're the former employer, you're going to have 20 days to then submit this information to the requesting district or contractor for that and move forward. And so this is going to be a big deal. In the future, there's going to be a template that we create at the time of separation of employment with all employees. So in the future, you will already have something in the personnel file to be able to send. But of course, that's not going to help us going back for that. And this is going to be a big deal and a lot of work and very difficult. The second piece of this is the section that requires parent notification when there is an allegation of sexual misconduct. And anytime there's formal action, including accepting the resignation, that we're supposed to do that. So there is some very specific processes in place for that as well. So I want to make sure that we are paying very close attention to those requirements and are ready to do that. It's going to be a lot of work. It's going to be very difficult. This is a real quick 5-minute overview of those requirements. Again, there's more information in our recent newsletter and on our website about those changes. And obviously, this is something we're going to be talking about a lot and in lots of places and with many of you over the course of the next 6 months as we get ready for compliance on July 1. I see the note here about, we're doing questions through the Q&A, not through the chat box. So if you've got a question, please make sure you're doing that through the Q&A and not the chat box. The other question that I want to make sure that we are putting our thoughts to relates to student social media and how courts are really unpacking what the Supreme Court did last year in the Mahanoy decision that I know we've talked about in the past. We just got a Ninth Circuit decision here a couple of weeks ago. And so that is something that we're going to have to plainly think about. And so I want to think about the facts of this case because I think they are relevant. This is a case that's been out there for a long time, working its way through the courts. And this case specifically relates to a student who created a private Instagram account that he only allowed his close friends to follow, in which he posted some pretty bad things, right? Making fun of students, but also some things that were clearly vicious, racist, violent, specifically targeting some Black classmates, making references to things like slavery and lynchings, using the N-word frequently. And of course, even though it was a private account, of course, screenshots were shared, it was leaked out, and it became a very big deal in the school, right? So a very big deal. And so this student sued saying basically, hey, I can't be punished for my away from school private Instagram account, that violates my free speech rights under the First Amendment. And the Ninth Circuit affirmed a decision here in favor of the school saying yes. And what's interesting here is they really took the Supreme Court's decision last year in Mahanoy and kind of filtered it through here and really looked at those exceptions. And so they first started by saying, hey, it's clear that if this had happened on campus, clearly these are statements and comments and actions that a student could be disciplined for if they had occurred on campus. And so because it was off campus, we have to look at, those Mahanoy factors, and the Supreme Court said in Mahanoy, for example, severe bullying or harassment targeting individuals, threats of violence, those things are not protected speech under the First Amendment, even when they're away from school, non-school time on social media. And so the court here said, even though this was off-campus Instagram activity, there was a sufficient nexus and it did hit those Mahanoy factors. And I think that's important that they were saying, look, given the ease with which those electronic communications can be shown to others, it's plainly foreseeable by a student that might ultimately be learned about by those that they're making fun of and at school and become a big deal at school. And the way the court put it is, while the student emphasized that he never intended for the targets of his post to see them, court said, but having constructed, so to speak, a ticking bomb of vicious targeted abuse that could be readily detonated by anyone following the account, he can hardly be surprised that his school did not look the other way when that shrapnel began to hit its targets at the school. And so ultimately they said, the school had an obligation here to protect other students from being harassed on the basis of, among other things, race, and that they could have been liable if they had failed to respond adequately to this racially hostile environment once it became aware of it. And so that was not protected speech as to this student. The other student appealing it, the student named Chen, said, hey, I didn't create it. I didn't make the post. All I did was follow the account. he liked a couple posts and he made at least one comment where he sort of denounced another follower who had criticized the post as racist. And here the court said he can also be disciplined under the First Amendment, saying that he's akin to a student who eggs on a bully, who torments classmates, and the school may properly take account of such affirmative participation, what ended up being as abusive harassment targeting particular students. And that the severity of the hostile environment was exacerbated by the fact that this student, like others, had participated in the account and liked the posts. So I just think that that's really interesting. There's an interesting concurring opinion in that case relating to hate speech that I think is, I don't know if the Supreme Court would go there, but I do think this is important to recognize that we are still walking that tightrope between responsibility for dealing with things like sexual harassment or racial harassment, even when it's happening potentially outside of school, and that the First Amendment both permits us to do that and that we may have other legal obligations to do so. So I think that's a really interesting one to think about for us. So again, if you've got questions, pop them in the Q&A box. And as we go forward, we're going to move on to some important updates from OCR and OSEP from Anna. So Anna, I'm going to turn things over to you to talk about these updates from OCR and OSEP.
Okay, so there's been a lot of guidance and changes in the law recently with regards to student discipline. In July of 2022, there was new guidance from OSEP OCR regarding discipline and specifically students with disabilities, which I will discuss some highlights of in a little bit. There's also some recent Secret Service Department of Ed guidance in May of 2022 regarding student discipline and threat assessment in schools. In Illinois, we saw SB 100, which prohibited suspension, expulsion, or referral to an alternative school for a student unless all other appropriate and available alternatives were exhausted. SB 100 also highlighted that importance of implementing conflict resolution programs rather than traditional in-school suspensions. Illinois has also begun to require districts to have threat assessment teams. And those teams are important when determining whether or not a student can be disciplined or needs to be disciplined in the wake of a potential threat. And so that's where I'm going to start my brief discussion because that has some impacts on students with disabilities as well. And so obviously schools are permitted to discipline students for on-campus and off-campus speech that demonstrates an identifiable threat of school violence. Courts, federal and state agencies are in agreement with respect to that principle. And there is no First Amendment violation when you're disciplining off-campus speech if the speech in question relates to a clearly articulated threat to the school. And that's especially important in light of the recent Supreme Court jurisprudence, which Brandon briefly mentioned in Mahanoy, where SCOTUS limited school regulation of off-campus speech. Just as a reminder, that's that case where the student posted on social media off-campus, F school, F softball, F cheer, F everything, although she did elect to use the full curse word in her Snapchat. And so that's why, threat assessment teams are so important in districts, as they help to determine whether or not there is that identifiable threat. But those threat assessment teams need to be able to understand a student's disability, if applicable. And not understanding the disability can mean that the threat assessment team is unable to appropriately respond to the threat in question. OCR is found against the school district's threat assessment team because they failed to account for a student's disability and how that disability might have impacted the threat being made. It's also going to be important to consider student mental health issues for that threat assessment team and the impact that those might have on a student. So now I'm going to briefly discuss some of those highlights and important pieces from OSEP and OCR. Before I get into a little bit of the minutia, I do want to explain a little bit why it's so important. And students with disabilities are disproportionately the same students who are most often excluded from school because of discipline. There's 2017-2018 data for K through 12 students that K through 12, those students were 13.2% of the total student enrollment, students with IEPs were, but received 20.5% of one or more days in school suspension, and 24.5% of one or more days out of school suspension. And those numbers are even starker when you compare it with federal data for students with IEPs and those students who are subjected to physical restraint and or seclusion. And the disparity is also even more apparent when you are looking at minority students. 2019-2020 data says that Black children with disabilities made up 17.2% of children aged 3 to 21 with IEPs, but accounted for 43.5% of all children with IEPs who were suspended for more than 10 school days or expelled. So these are pieces that were shared by OSEP. And the first one is important because they are essentially telling districts that if you fail to properly and proactively address the behavioral needs of students, you might be in violation of LRE. And that's important when you're talking about a federal agency who might come and investigate you later, telling you what they might cite you for. So districts need to be looking closely at what is being done for students with disabilities and whether or not what is being done is working. If it is not, meaning the student is having behavior issues still, districts need to consider what else can be done. OSEP is also clear here that a disciplinary removal includes a shortened school day. So when determining if a removal is warranted, OSEP says that districts need to be clear about their consideration of the following factors. And as an attorney, I'm going to tell you to document considerations of these factors and why any decision to discipline was reached. And remember that while a manifestation determination review must be held if a student is suspended for 10 or more total school days, you do not have to wait to hold such a meeting until those 10 school days. If behaviors from a student are becoming worrisome or repeated, consider holding an MDR or an IEP team meeting sooner to discuss what interventions or accommodations could be utilized to address behavioral issues. So OSEP also provided some guidance with general ideas for assisting schools in reducing aversive practices and exclusionary discipline for students with disabilities. Those include things like universal supports, EBIS, targeted supports, FPAs and BIPs, investing in school and educator capacity, cultural and linguistic responses. This guidance especially is, in my opinion, a great resource guide for districts and educators because it gives some of those ideas of what you can do instead. So this is just another reminder that, OCR and Section 504, you still have to hold that manifestation, essentially a manifestation determination hearing anytime we have those issues regarding changes in the student's placement so that we can ensure that the student receives FAPE. And so in the next slide, we're coming back full circle to threat assessments and considering students with disabilities in your threat assessment teams. And so if your district is utilizing a threat assessment and it's a student who has a 504 plan, then the district under Section 04 must also ensure that it is fully considering the impact the student's disability might have on the threat made. That's going to ensure that the district is not guilty of disability discrimination and is going to ensure that the student's FAPE rights are properly safeguarded. And so these are what I would say are the main takeaways from the new guidance. Now, how to do this? I think one way is to evaluate behavior before it becomes an issue that is requiring a manifestation determination review. I think another way is to assure that staff that are involved in conducting threat or risk assessments, especially for a student with a disability, are aware of the student's disability and are sufficiently knowledgeable about the FAPE requirements so that they can coordinate with the student's Section 504 or IEP team. Also, just a fun reminder that OCR said in May of 2022 that it was going to begin the process to overhaul the Section 504 regulations. So, and with that, I think I'm turning it over to Christine.
Thanks again. I think that's a topic that we posted a little bit about in our most recent newsletter on our website. So if you want to dig in some more, it's there. But I'll turn things over to Christine, and then after Christine, I think it's going to be time for our Q&A. So keep those questions coming into the Q&A box.
Excellent. Thank you so much, Brandon. There have been a few allusions today about student mental health, and so I wanted to go into a little bit more depth about 3 areas that I'm seeing crop up more and more related to student mental health. First of all, some new laws that have been passed that address and attempt to strengthen student mental health. Number two, the 504 implications that could be in place related to student mental health. And then finally, some new litigation that you might have seen crop up or Twitter and the internet. There's been a big buzz about student mental health and social media, and that's a new litigation. So we'll finish up with that. So first, let's talk about some new laws that have been passed to address student mental health. First of all, there is Public Act 102-416. And this says that effective January 1st of 2023, each school district that serves pupils in grades 6 through 12, and that issues an ID card shall provide contact information for the National Suicide Prevention Lifeline, the Crisis Text Line, and either the Safe to Help Illinois helpline or a local suicide prevention hotline, or both. Now, I at least have been having some difficulty keeping track of the date now that we've gone into 2023, but just as a reminder, we are past that January 1st date, quite a few days, in fact. And so if you do issue ID cards, please make sure that that information is provided. If it's not already provided, please provide it post haste. But there is a second part of this Public Act 102-416, and that's that this crisis information that I've already discussed from National Suicide Prevention Lifeline, the Crisis Text Line, and either the Safe to Help Illinois helpline or local suicide prevention hotline, or both, that must be included in the school student handbook and also the student planner if the student planner is custom printed. I will say I have reviewed a few handbooks this year, and I have not always seen that information added. So if you're looking for something to do tonight, please go through your handbook. And if you have a custom planner, to make sure that that information is provided. Not to overstate this, but that information literally could be life-saving for a lot of students in a difficult place. The last law that I want to review here, and I'm sure you've seen it before, but it bears repeating, is Public Act 100-810. And this states that valid cause for illness includes the mental or behavioral health of the student. And under that Public Act, absence for cause by illness is required to include the mental or behavioral health of a child for up to 5 days, and the child does not need to provide a medical note. And the child must be given the opportunity to make up any schoolwork missed during the absence. They do also add that after the second mental health day used, the school district may refer the child to appropriate school support personnel. And that may word leads into my next point about child find. We may think that student mental health is kind of off in a little corner by itself here, just with the implementation of these new laws. But just as a reminder, if a student does have mental health concerns, there may be implications under Section 504 and the IDEA. Now, I think we're pretty comfortable with the IDEA, so I wanted to focus today on Section 504. Now, under the Section 504 regulations, a student is eligible for 504 coverage if his or her impairment is one that substantially limits one or more activities. Now, I want to pause here for a moment because I think sometimes there's a misunderstanding with Section 504 that it's just limited to students who need accommodations or need services and therefore have a 504 plan. That's not true. Section 504 is a general, broad, non-discriminatory statute. And so there may be situations in which a student has an impairment that substantially limits one or more activities that does not need a 504 plan. And that's a technically eligible child. And even in situations in which they may not need a 504 plan, they're still covered under Section 504, which means that they can raise claims related to discrimination as well as retaliation and harassment. So getting back here about Title II of the ADA, OCR in particular, which interprets and enforces Section 504 at the agency level, has made it very clear that there are certain impairments that will virtually always substantially limit a major life activity. And those include major depressive disorder, bipolar disorder, PTSD, a traumatic brain injury, obsessive compulsive disorder, and schizophrenia. So if you have a student that has these mental health concerns, please be aware that in addition to holding up these new laws, there may be some child fine implications and Section 504 non-discriminations provisions that they are covered for, that they're entitled to. Now, to just kind of reinforce this, I want to cover a specific case that came out of Pennsylvania out of 2018. Now, in this case, what had happened is that a parent had been very communicative with a school district that her daughter had an anxiety disorder. The parent and the school communicated back and forth about the student's incomplete work, the difficulty that she had in completing the work because of her anxiety, her absences, and other matters related to the way that this anxiety disorder manifested itself. And they eventually ended up having to have truancy meetings because of these students' absences. And during that truancy meeting, they once again discussed the student's anxiety disorder and how it impacted her absences. But despite these repeated conversations and the notice that they had that she'd been diagnosed with anxiety, the school waited 2 months after the truancy meeting before providing what they call 504 paperwork. Now, the parent promptly returned that paperwork, but the district did not conduct an evaluation, and no 504 plan was ever developed, even though, as we can see, this anxiety disorder had been affecting her schoolwork. Do you want to know the reason why the school district gave an explanation for why they didn't give an evaluation or a 504 plan? They claimed that she wasn't eligible because she got great grades. And so they found there was no way that the student could possibly be eligible for 504 coverage, even though she'd been diagnosed with anxiety and it was impacting her attendance and her ability to work on assignments. As you might imagine, the hearing officer was not sympathetic in this case, and they found that the district discriminated against the student under Section 504 by not promptly evaluating and providing a 504 plan. And this was very costly to the district. The hearing officer ordered an independent educational evaluation, meaning that it would not be school officials that would be conducting that evaluation, but a private evaluator. So I can let you fill the blanks about how expensive that was. And the hearing officer also ordered compensatory education. So please remember, if you have a student that is presenting with some mental health issues, there may be child fine implications under Section 504. Finally, I wanted to cover a litigation that has been cropping up over the last several days. You've probably seen it talked about on Twitter, on the news, and this is a case coming out of Seattle Public Schools. They have filed a lawsuit against TikTok, Instagram, Facebook, YouTube, and Snapchat. And the district is alleging that these social media companies have created a public nuisance by targeting their products to children. Specifically, they're claiming that these companies have worsened mental health and behavioral disorders of these students, including anxiety, depression, disordered eating, and cyberbullying. They've also claimed that these companies have made it more difficult to educate students. I'm sure that you all can relate. It's much more difficult to have conversations with people when social media is on their phone. They're also claiming that it has forced schools to take steps such as hiring additional mental health professionals and develop lesson plans about the effects of social media, and that the school district has had to provide additional training to teachers. Now, you might wonder what the end game here is. I obviously cannot speak to that, but they have cited data here that I think is pretty compelling. They're claiming that from 2009 to 2019, there was on average a 30% increase in the number of their students who reported feeling so sad and hopeless almost every day for 2 weeks or more in a row that they stopped doing some typical activities. And Seattle Public Schools is requesting that the court order the companies to stop creating the public nuisance, to award damages, and to pay for the prevention, education, and treatment for excessive and problematic use of social media. It will be really interesting to see how this case progresses, to see whether there's any kind of settlement. I think certainly the district is looking for, at the very least, this prevention education. But in summary here, I think we've discussed over the past couple of minutes how student mental health can affect a number of things. And so when we're looking at enforcement, please make sure that you're following the new laws that have been passed, as well as being aware of the child fine implications. And we will see what comes of the Seattle Public Schools litigation. All right, thank you.
My question is whether or not Twitter has suspended Seattle Public Schools Twitter account yet. For
That's an excellent question. Let us know in the comments below.
You know, I think the other thing that occurs to me about a couple of those those things, Christine, is just not only how important they are, but I think it's interesting that Seattle's deciding to take that proactive step, but I also think, the reality of the impact is that there was, data there that they knew about the effects they were having and continue to go ahead. So that definitely reminds me of the tobacco litigation and all of that. And some of us who've been around for a long time remember that we at one point at schools got some tobacco settlement money. So maybe we're going to get some TikTok settlement money at some point in the future. I don't know.
Wouldn't say no.
Well, we've reached the point where we've got some questions here in the queue to talk through. So please don't be shy about more questions anybody has to ask, and we'll do our best to answer them. But David, I think a couple of the first questions came out of your presentation. So I'm going to let you see what you have to say about a couple of those first.
Yeah, so there are a couple of here that I want to address out of the gate, having to do with CPI increases as well as 6%. So one of the first questions that came in was regarding how the 6% cap is treated with regard to CPI being really high. And I'll sort of reframe the question as, is TRS going to do anything about that? So a couple of things. First, we have a new administration at TRS. Every time we get a new administration at TRS, we get new rules, and we also get new interpretations of old rules. So I want to caution right now that while I may have been real sure how TRS would have interpreted a particular issue, if you'd called me 4 years ago, you might have gotten an answer on something and thought, okay, I know the answer forever now. Every time there's a new administration, and several of us on this call have seen several administrations, and the reality is when there's a new one, there are new interpretations of rules. So first, look out, things may change. Second, the 6% increase is set forth in the law at 16-158 of the pension code. And without having you go through the entirety of the tax code to find that, pension code is a tax code in the state of Illinois, be alert that there is no exemption on the basis of either minimum salary or 6% caps set forth in 16-158. Now, that's not to say that TRS won't sort of imply one of its own volition. They've done those kinds of things before, nor is it to say that there aren't bills coming. There are bills and other such things in the works for all kinds of different things, but be alert that as drafted right now, 16-158 does not have an exemption for a CPI increase that is out of control. And the third thing that you should be aware of, and if there's a theme from my part of the presentation today, it may be use it as a shield, not a weapon. There is a law sort of buried in the school code. It's 2-3.103 that sets forth a survey of teacher salaries. And TRS is empowered to review that survey. And they do have a rule. It's 165481A10. It's for my own notes for later, if nothing else, that sets forth an exemption if the salary that was paid on the basis of that is penalized on the basis of a 6% violation is below that mean salary for teachers throughout the state, then there may be an exemption for that. But again, remember that TRS makes these determinations themselves, and you don't have an effective means to challenge it, because your only means to challenge it or go to court and argue that TRS misapplied its own rule. And of course, the court looks for their expert opinion on what TRS's rule means to TRS. So it's not effective to challenge them because they're going to be there in defense of themselves and as their own expert. So it's just not feasible. And second, you're not very likely to get an exemption on that anyway. And so, it's just too much money to spend on one teacher to try and get that money back. It's just not very likely to happen. And it's high risk, very low reward, because you're going to spend the same amount of money to go to court. So therefore, it is better to ask permission than forgiveness. If you're looking at a salary increase in excess of 6% and you think, I think I can get away with this. This happened last year in summer school. We saw everybody needing to do summer school because the federal government was all but requiring it and providing all kinds of money for it. And then we ran right into the statute which says no. Now, TRS's rules said there was an overload, but there was an exemption you had to ask for. And then it had expired. It expired right as the summer began. So we went and got a legislative fix. Legislative fix fixed it in arrears. So we got 1 year, but that of course has expired. So again, go ask for permission, not for forgiveness. The second thing that I saw in here was we need clarification on auto CPI increases. Is that for all or only for those below 40,000? The answer is the law only establishes it for those below 40,000, but, and it's a big but, if you don't have a system in place for how that works, the union may have a different view of what that does to the schedule. In other words, if we've always inflated the schedule by whatever the base is and the base goes up, the union may have a belief as to what that means. Now is the time to have that conversation. If you don't know what's going to happen, now is the time to begin the conversation about what the process is. What does your contract say? And every contract is different. I have some bases that are totally divested of the salary schedule. I have some minimums where schools have agreed that will inflate only to minimum salary, whatever that may be, but it doesn't affect the rest of the schedule. I've got some places where it's going to auto inflate, and some places people know that, and some places people don't. So be careful that you have had the conversation with your union about what's the practice in your district and how that's going to work.
And I think where that's going to become a practical problem for us, really, I think more so starting this year, while we're still a couple of years away from that minimum salary automatically going up by CPI. So I'm still holding out hope that by the time we get to 23, 24, inflation has come down to a reasonable place where we're not worried about that so much. Otherwise we are going to be in quite the place if we're keeping inflation at these rates over the next couple of years before we get that, but also recognizing that
23, 24 is coming up fast, man.
Yeah, that's my other point. When we get to those next out years, we're going to be bargaining now for those years, right? So when we get into a 2-year, 3-year, 4-year contract, we're bargaining for those out years. So we're going to have to keep that CPI component in our mind as we think about what that base starting salary is over the next couple of years. Another question here, back to our Faith's Law trailer bill and those background check changes. And let me again just say, this is just going to be such a big deal. I mean, I know I went through it quickly. I really encourage you to take a step back, read through it, and sort of process what that's really going to mean. And we're going to have, there's some work there for ISB to do in creating templates and things. But the question here is this for those hired prior to July 1st that start after July 1st. The way the statute is written is for those who are hired after July 1. So I think if you're hiring somebody this spring for next school year, the way I read the statute, unless you disagree with me, anybody else, is that it's going to apply to those who are hired after its effective date, and its effective date is July 1. So to some extent, there could be some benefit in, not that we're trying to avoid this process, because this process exists for an important reason. But I think for somebody you hire now to start July 1, you're not going to have to go through that process. But any applicant hired after July 1, you're going to have to go through that background check process required by the statute, and make sure that we're updating those forms. And there's some tricky lines to walk there with some due process issues, with some, we're talking about the difference between founded allegations and unfounded allegations. I think this is a tightrope, and there's going to be some messy litigation about that one way or the other when somebody's not hired for that, or also if somebody is hired and something bad happens, we didn't follow the process, right? So I think that is important. The other question here for clarification is that for contractors or employees, it's for both, right? The statute applies to anyone employed by the school or any school contractor for whom there is direct contact with children or students. So it's going to apply both to our own employees and to our third-party contractors. There are some special provisions there about subs that we just don't have time to get into in detail today. So I encourage you to link through to the statute and the summary that we put in our newsletter. So as we think through some of these other questions, other issues that are out there for us, please don't be shy. I want to emphasize and maybe follow up with a couple of things that everybody else talked about. And I think first, I think a point that, Ellen made that's really important because I see it way too often. And I guess, Ellen, I would ask you your thoughts here. I know one of the things that you emphasized was sort of that intake process with Title IX. How do we start down that path? And what I'm hearing frequently is we've got some districts that have maybe started following more of a traditional or typical, student discipline investigation process. And then either we're figuring out, oops, this is Title IX. Oops, I didn't think about Title IX. And maybe we've got the wrong people involved and we didn't involve the Title IX coordinator. How do you put that toothpaste back in the tube? And what do you think the best way to approach that is in those situations?
Yeah, I think you just take a step back and you go back and you do it. It is a process that is required. It is there for a reason, to ensure that everybody is aware of their rights and is provided with supportive measures. And I think a failure to engage in that process could cause liability. So I think you just take a step back and you have a meeting with the Title IX coordinator. You just go back and do it. Even if you realize 2 steps in that you have done the wrong thing, move back and start the process from where you're supposed to start it under Title IX.
Agree.
I think that as I look through our questions here, our popcorn has stopped popping. It's not, David got so used to during all of our COVID webinars, people we couldn't get through all the questions. And now everybody is sort of like, we don't like these topics, right? These are things that this isn't, we just want to not hear this. But I do think these are all things that are so important because, they're the things that we see crossing our desks where litigation becomes a real issue and hard to undo once we've done that. And I think it is really essential to think that through. And so I do think on each of these topics, there's a reason why we chose them, because there are things that we are seeing that we want to make sure are on your radar because they're important things for us.
Yeah, and I'll highlight something you said earlier, Brandon, when we were in our recent small group meeting. You said the most alarming thing was sitting at that attorneys conference in Chicago and listening to everybody listening to a presentation by people who really know this stuff well on face law, and they don't know how we're going to comply with all this stuff. And that, I mean, one, for us as attorneys, it's a little relieving because when you walk into it, you feel like you're knee deep. I don't know how I'm going to get through this. What am I missing? To hear somebody else who really knows this stuff say, I don't know how we're going to do this. That's alarming, but it is also somewhat relieving. But I can't emphasize enough on that issue that compliance with that. Brandon, you said COVID. We spend so much time talking about that tort immunity shield, that tort immunity shield, that tort immunity shield. This is one of those, like, if we can check this box and we can show that we did it, then we don't potentially breach that tort immunity shield. But in these sexual harassment cases, in these sexual abuse cases, that ability to show that you checked that box is so important. And there are so many boxes to check. Being aware of what you've got to do, making sure that you've got the right training, making sure that you've gone through all the procedures that you're required to before you hire somebody is just going to become so critical. And so the more that you can hear about that, if you see face law on something, go to it, listen to it. Even if it's somebody else given the presentation, listen as much as you can, because the more you can learn, the better off you're going to be.
And I think a point that's not lost on me is we take that issue and we kind of play it out. I mean, every single topic that each of us talked about today comes back to that. So if you've got a situation where you've got that inappropriate interaction between staff and student, first of all, you've got a potential dismissal and employee discipline and personnel records issue, all the stuff you talked about, David. Clearly, it implicates the Title IX process that Ellen talked about. Obviously, we've got our faith law pieces that I talked about, and also certainly there is the relationship to the student discipline side of that and students with disabilities, and exactly what Anna talked about in terms of making sure that from the student side of that, maybe the student also acted inappropriately in that conduct. And if they have a disability, the additional provision, and then the reality of that it happened and the trauma and mental health outcome of that Christine talked about from, now that student has depression, anxiety because of that interaction. So all of these topics actually all relate, so, they're layered on purpose and by design, because there's so much interplay between that. And that's why it's so important to recognize that when you see a situation happen, this is not just a labor issue or just a Title IX issue or just a bargaining issue or just a First Amendment issue or just a special ed issue. It's all of those at once. And that's what sometimes makes it exciting for us to have to go, oh yeah, we've got to think about all those things at once.
And that's why there are so many of us here, right?
Well, I don't see any more questions in the chat, and anything from anybody else for the good of the cause. Otherwise, I think we'll wrap things up and appreciate everybody hanging out with us this afternoon.
Thank you all so much for coming.
Well, thank you again. We'll post the materials on the website, as David said in the chat here, in the near future, and look forward to that. Check out some of these lengthy articles on these topics that are posted on our website, and we look forward to seeing you all soon. So thanks so much, everybody.